Okay. Hi, everyone. Welcome to week three's lecture for chapter three, which is on criminal law. So, thinking about the chapter and thinking about our notes, there will be a little bit of back and forth, kind of almost like the first week where I went between text pages and the actual lecture whiteboard notes that I put up. So I just wanted to let you know there will be some back and forth stuff. So if you are watching this, apologies if it gets a little quick. Not trying to make anyone sick or anything. If you're just listening to it, that's fine. You can always look at it later, that kind of thing, and scroll through it. Anyway, so our author talks about chapter three, criminal law, and how it's almost everything that we understand as these terms that we are talking about and use, like criminal law and the judicial system and criminal justice, and they're more of catch-all terms anymore. They cover a lot of different sub areas within the field of criminal justice. And so when we're talking about criminal law, our author is really talking about substantive criminal law, which is the part of the law that describes what acts are prohibited and what punishments are associated with those acts. So these are where we're getting into the actual nitty gritty of what a law is, what kind of laws are punishable, that kind of stuff. And so it's going to actually play in really well to part of our special topics for next week, as well as the essay. Anyway, remember going back, and our textbook says it, and I'm saying it too. Remember, go back to first chapter and the second chapter. Laws are the basic rules that we as people agree and understand as how we should act, because that's what society deems, and we need to do that. So keep that in mind. These are just sets of rules that we've put forward. Some of them go back way longer and others don't, and we'll talk about that here in this chapter, here in this lecture. And so our author kind of breaks down that there are really two subsections of substantive criminal law, and these are terms that you've probably heard before if you're at any way, shape, or form been interested in the criminal justice field for a while. You've heard the term misdemeanor, Demeanor. Sorry, I may be an English professor, but I'm not great at spelling. And then the other one is felonies. And so it's important to note that these are the two breakdowns that our author is giving us. This is the more common understanding to explain the distinction between the two of them. Misdemeanors tend to be minor crimes. And these, hold on, I'm going to expand this box just a little bit. So these minor crimes, these are things that have a equal, because sorry, I cannot type and write and speak at the same time. So misdemeanors are these minor crimes with minimal punishment. If we remember, one of the big things of law and the quote-unquote punishment for breaking a law is supposed to be, similar in how it comes forward. So it is not cruel and unusual, which is something from this chapter and we'll talk about later. But it should be fair. It should be equivalent. It should be fairly equal. And so the misdemeanors tend to be the smaller crimes with smaller punishments, whereas felonies, these are the ones. These are with severe punishments. You would never see a misdemeanor result in a death, but a felony would result in a death. Like, severe punishment for a major crime, minimal punishment for a minor crime. Misdemeanors are, things like public indecency, public intoxication. These are sometimes referred to as victimless crimes. These are, pirating a DVD or video game or movie or TV show or textbook or something from the internet and you didn't pay for it, so you stole it. That would be a misdemeanor. It's not a felony. It's a misdemeanor. It was a minimal crime and didn't really affect that many people, so it has a minor punishment. Now, of course, if you stole a movie and then sold it to millions of people, it gets into a different area. Anyway, I just wanted to kind of bring forward those two, as you've probably heard those terms if you're interested in criminal justice and you're here. But if you hadn't really thought about it before, this is really the distinction that's being made. And so our textbook does provide us with some Latin words, and I'm going to give us our Latin words that we see. It's mala in se and mala prohibita. And so this is also where the breakdown between misdemeanors and felonies comes in. This is another set of standards that is used to understand crime and how severe crime is. So mala in se is closely translated, and the text does say this, to, a wrong that is wrong. And so I choose to use the phrasing inherently wrong because it means inherently is you deep down inside know right away that it's wrong. So mala in se crimes are murder. You're not supposed to kill someone. You're not supposed to light houses on fire. It's wrong. But mala prohibita is wrongs that are wrongs because society says so. That's really the biggest difference. So when you think about laws that have been made, I'm not taking a stance on this, but public nudity is a mala prohibita. There are nudist colonies out there. There are people that believe that we were born without clothes and we should live without clothes. It's only wrong and illegal because society says it's improper. It's not inherently wrong to be naked, if we're using completely like that logic. But mala prohibita is also, don't smoke marijuana, don't drink if you're under a certain age. Like, these are things that are wrongs because society has deemed them to be wrong. A group of peers or similar people have agreed on these terms. But the inherently wrong things, these are the big no-nos. Don't steal, don't kill, don't light things on fire. You tend to know those. I shouldn't have to explain those types of rules and laws. I think you all know them without knowing them. And so there's going to be, I believe, another couple Latin words that come up. And when they do, I will talk about them just briefly. They are important in the fact that, they're part of the system. But it's more important that you understand what they mean rather than the term itself. Because you're not necessarily going to be saying, oh, that's a mala prohibita. No, you know what it is. So if you do go into, the subsect of the law that is being a lawyer, you should know the Latin. But unless you're going into criminal law, it's not the most important piece to know the Latin words. But you should know what they mean. All right. And so in thinking about criminal law, our author also breaks down a couple different subcategories of crime. And so I want to put out the types of crime that our author puts forward and just kind of talk briefly about those. Oh gosh. Okay. And of course, I knew I was going to do something wrong, because that's just the way it goes. All right. So our author breaks down that realistically most crimes, whether they're inherently wrong or wrongs that are wrong because of society, whether they're misdemeanors or felonies, they tend to fall in one of these four categories. And I think it's a kind of good way to think about it. So street crime is the most obvious stuff. It's the things that are, you tend to see in a lot of TV shows and whatnot, you tend to think of this when you think of crime. You think of, burglary, you think of shootings, you think of murder, you think of these are the street crimes. They're the highly visible crimes that tend to be well known. Occupational crime is really, it's a very specific group of crimes. One of the most popular, and it's weird to say popular in this sense, but one of the more popular crimes that is occupational is embezzlement. And this is because the idea behind occupational is that your job, your occupation, provides the criminal opportunity for you to do that crime. So street crime is just, it's visible. Occupational is I'm at a job and I work in finance and I take $20 off the top every day. And so by the end of the year, I've made this much amount of extra money that's off the books. Like, that's embezzlement. That is illegal. And that would be an occupational crime. Obviously, I'm sure when I say organized crime, you can almost immediately will think of gangs or the mafia or the Yakuza, depending on who you are. Like, these really break down to any kind of crime that's committed by a group that has a discernible structure. So it's not just, that's Lenny, George, Carl, and Frank. They all, run the same racket and they do this. They're not an organized crime group. They're just four guys that happen to always do the same thing. An organized crime group is something where you can see a structure where, there's a hierarchy, there's people that respond to certain individuals, that kind of thing. I will definitely admit that in my own graduate studies on criminal justice, I did an entire class just on organized crime. So there is plenty to talk about with this. It's more than just, it's a group of people. There's a lot more to it. But for an intro to criminal justice course, this is not the place or time to do that. The other thing I will say, and the reason why organized crime is different from street or occupational, despite having a little bit of both, is the idea that because of the organized structure, the organization, and the groups of people involved, it tends to have a bigger impact. It hits more people. It's involved in more things. Like, there tends to be more damage because of the group aspect of it than if it was just an individual or a couple of people. So that's another part of that distinction that's important to note. Our author does mention that. I just want to make sure that you are clear in it. But it is the cliche mafia kind of example. And then obviously cyber crimes. It's really sad that, we have just a catch-all term for anything that involves the internet and computers. But obviously things like phishing, and I know you've probably heard phishing before, so I just kind of want to do a little post-it note on phishing here instead of doing anything else. So if you haven't, phishing, it's spelled like that. I promise it's not a misspelling. It is some kind of attempt to obtain some kind of identifying DNTIFY information through fraudulent means. So the reason I emphasize this is because phishing is very big in the cyber world and the cyber crime nowadays. You get the spam emails that say, hey, you won, click on this link, and then you put in your information and all of a sudden, that's a phishing thing. Obviously you might be familiar with catfish, which was, people were pretending to be other people online on dating sites and meet up with things. Like, the whole point of phishing is you're attempting to obtain some kind of identifying information through a fraudulent means. It tends to be those, you won. Or like, if you've ever seen, they're on YouTube, and I highly recommend watching them to see, figure out how some of these individuals do it. There's plenty of people that get back at scammers and scam call centers. Kitboga is one of the big ones that does it. I highly recommend if you know someone or have yourself fallen for a phone scam or something, this is a phishing type scam, and I encourage you to watch how he approaches them, and you learn a little bit, and it's a little bit funny and ridiculous. It's worth a watch at least once. But when I talk about cybercrime, like I said, this is the umbrella term because how do I want to say this? Despite the fact that we've had the internet for several decades now, we still don't have a whole lot of laws and regulation on the internet or on technology. And so that's kind of why this is a catch-all term for just cybercrime, because we haven't really broken down these into deeper and further areas. So please just keep that in mind, bear that in mind. It's doesn't have a big impact on you in any way, shape, but I just wanted to, let you know. So we're just going to put phishing right there because it's a post-it note, not an actual piece. And so in regards to, crime itself, I can't help. The textbook mentions it, and every time I see the word, I think of an Office joke, and I shouldn't because it is a serious thing. But one of the things our author does talk about is hate crime. It's obviously, it fits under all this, but hate crime, I always think of from The Office, Michael Scott's character saying, "I was the victim of a hate crime." That's not what you think it means, Michael. Well, I hated it. It's a misunderstanding of what a hate crime is. And it's important to note that, and like I said, I hate that we have to continue to have this conversation in 2022. And as we continue moving forward, we still have to have this conversation. But a hate crime is any type of crime that is motivated by a bias towards a particular race, sexuality, religion, ethnicity, etc. So a hate crime is intended for a particular audience. It's not, you're picking on one person just because, you don't like that person, they annoy you. That's not a hate crime. If you are picking on an entire group of people because they all believe the same thing, or they all look the same, or they all dress the same, that would be a hate crime because you are making it because of that particular shared identity. And so I just wanted to emphasize, because sometimes we get caught up in the idea of a hate crime. Just because you are a person of a different color or religion and someone treats you wrongly doesn't necessarily mean it's a hate crime. If they do it because you are that other race or religion or belief or whatever, then yes, it's a hate crime. This is why it's very political and difficult to talk about things like police brutality, is because does it toe the line of hate crime? Yes. Is it necessarily a hate crime? That raises some questions. And so it's something that is not necessarily for an intro to criminal justice class. It's more of a, let's talk about this in ethics class or a philosophy class. So we're just going to move on from there. And so our author and the chapter takes a little bit of a turn and starts talking about the legal side of it, the law side, the thing that I really like, the lawyers and judges and all that other stuff, and the court system. Don't get me wrong, this stuff is interesting and I'm really excited to talk about it, but I love the courts. Can't help it. So we have two different types of courts. We have civil court and we have criminal court. And if you were all in a physical classroom with me, or this was a live session, I'd say, what's the difference between a civil court and a criminal court? And then I'd give you a couple seconds. But because this is an online lecture and I'm just talking to myself, really the big distinction here is civil court is a private matter and criminal court is a public matter. And obviously it's way more nuanced than that, but this is one of the easiest ways to explain that breakdown. So under a civil court, the things that are being done, the wrongs that an individual is feeling, is referred to as a tort. So that's just a wrong done to another person. And so civil court is usually between people. It's between people and it pays in damages. There's not usually, jail time for civil cases. They tend to be just, these are the Judge Joe Brown, Joe Jackson, Judge Judy, like all those terrible guilty pleasure, because I totally watch them too, courtroom shows. They're all civil courts. They're all, this person didn't pay my rent. This person messed up my car. That's a civil court. It's between people. It's also important to note, and this is going to be an example that comes up again as we talk about this system, and it's one of those, I'm sorry that it keeps coming up, but there are some real world examples that have happened in the last few months that fit perfectly. The Johnny Depp Amber Heard defamation trial was a civil court. It was between people and arguing about whether or not one thing led to the other. That's what it was. No one was getting jail time from it. It was just going to be payment. Now, criminal court, that's the public court. That is where there is two parties, the party who committed the crime or allegedly committed the crime, and the state or whatever governing body. So like the federal government, if it was federal criminal court, but it would be the state. So this is where the idea and the philosophy of rulings on the court, criminal court is seen public because when you commit a criminal offense, when you are committing a crime that impacts, it doesn't just hurt an individual, it hurts the community at large. So when you commit a murder, you're not just killing someone, you are taking that life from the community. You are impacting the community. So that would be a criminal court. It's a public case. If you stole from a business and that business therefore was also, maybe in the process of stealing, you burnt it down. Let's just go with arson. Let's just take away the burglary. Let's go with arson. You burned down a business. The business is part of the community. It doesn't just impact the business, it impacts the community. It's a public issue. It's a criminal court. So that's the philosophy that is taken. Civil court is a private matter between two parties. Criminal court is the idea of this individual who may or may not have committed that crime and the community at large that has been impacted by it. So that's really the bigger distinction there. And so I just want to make sure that, we're all on the same page as we're talking about civil court and criminal court, because we are going to talk about the court system a little bit more in this, because, criminal law is the subject of this lecture. So, yeah. So I'm going to do my first actual writing thing of the day. Obviously, I'm trying out different note strategies. So if this works better for you, please let me know. And I will go this route more often. So I'll be honest, I did not have a good segue to go into this. So that's why I'm just writing it, because, I can't trust myself. So in the criminal justice system, we've talked about how, a lot of our laws come from, the Constitution and the Bill of Rights. And if it's not there, we tend to look back at it. Sometimes they're made by, the state system, and it's usually some kind of group that looks at it and things like that. But there's a phrase that's come up several times in the textbook, and this is the first chapter where we actually dig into what it is and what it means. And it's important to know. So we are going to talk about it, and that's common law. Sorry, my throat is drying out, so I'm taking quick little sip breaks between just to get something. Anyway, common law is an interesting concept. And so the history of it, this is the origins of common law. It's important to note that it's not American, as weird as that is to say. The origins of common law really come from this medieval England legal customs. It's important to note that these things were oral tradition. And if you aren't familiar with what that is, oral tradition is everything is passed down by word of mouth. Nothing's written down. Not that there wasn't writing at this time, it was a lot to write. So judges kind of just made decisions. And remember, this is also a time and in a place where there really wasn't a court. It was more of just, you took it to the judge who was, or rather, rather the term magistrate is coming from that era as well. This high up individual who rules on matters. And so the idea was that in this common law, whatever decision they made, they went forward and they made sure, yeah, that's what we do in that case. So next time some person decides to throw, honestly, all I can think of is terrible examples. So, like, throw someone into a pit of sick individuals, that person gets fined with this, or that person gets put in the stocks, or is killed. Like, that was the origins of common law. And so the common law idea in America and judges in America comes right from this classic idea. And so it's important to note that with not all oral traditions, but with a good number of oral traditions, eventually they did get written down, and some of them are still not, but this is one that was. And so common law, the English common law, and we're going to talk about that here in just a second, was really written down by Sir William Blackstone. He's the one that wrote down a lot of the oral tradition of that medieval England era law decisions. And so broke it down into 4-volume set. So, 4 separate books all connected together, and referred to it as the Commentaries on the Laws of England, which the founding fathers brought with them when they came to America. And so that's actually how the idea of common law got incorporated into the American judicial system. Is it's a British thing that we took and we went, yeah, that's a pretty good practice. We should keep that. Because it's important to remember history. We came from England to avoid persecution for religious belief. And eventually, we as a nation decided that, we didn't like the ignoring of our voice from our home country, so we started our own. So it's important to remember that it wasn't that the early American settlers said, oh no, England was terrible in all ways. No, they just disagreed in some areas. So a lot of our system is based off of that. So it's just important to remember your actual history. And so when we started to do this kind of modernization of laws here in America, both, in the earlier days and even now, these are defined as statutes, as we've talked about in previous chapters, but all of these are really based in common law tradition. And so when you think about it, and the easiest way to look at it is thinking about some of those old common law practices for certain crimes and how they have or have not changed. So the book puts forward some really good examples, and I like bringing up for sure murder. The common law practices and modern day practices on whether or not you are allowed to murder and what your punishment is tends to be pretty close. That hasn't changed much in the several centuries since that came into being. So that's one. One that is actually a really good example, and I trying to set this up without I'm trying to set this up so that you're not triggered. I'm trying to do this as understanding and inclusively as possible. So a slight trigger warning for SA or sexual assault. So if you are someone who has suffered from that, please know I am going to talk about one thing that is from common law that has changed over the years, but I do want to at least touch upon it here briefly. So this is your warning that I will be talking about that. Realistically, it should take maybe no more than 2 minutes. All right. So historically speaking, rape has gone through a significant change from the early days. That's one from common law that you weren't supposed to do that. But the older definition, and it's important to know, it's really just the unlawful carnal knowledge of a female without consent. That didn't cover spousal rape, which is something that is accepted now today. It didn't count any kind of homosexual rape. It didn't count a lot of things because it basically came down to unless a man put his penis in a woman's vagina without her saying yes and it wasn't his property, then it's illegal. That was the problem. And so nowadays, and this is important, like nowadays, it took us several hundred years to get here, but now the definition really goes to penetration, no matter how slight, of the vagina or anus with any body part or object, or oral penetration by a sexual organ from the other person without consent. Consent is the focus here in this new definition. It tries to be as inclusive as possible. So that is an example of something that has changed over the course from early common law days to now. But it's important to note that some things haven't changed, like murder. Tends to be the bigger issues that we see are wrongs with our evolution as a society. As we get to be more understanding, we tend to say, oh yeah, that's not okay. So, all right. One of the things that comes from the common law, but we've talked about before. Isn't that weird? We've talked about this. And I'm hoping that you can guess the word before I finish writing it. So I'm just kind of like taking my time a little bit. Because if you were in a classroom, I'd be like, all right. And I'd be slowly writing it on the board and hearing everyone shout out, oh, is it this? I'm trying to relive those moments with all of you online. Precedent. So the idea of setting a precedent comes from this practice of common law. So once a decision, if you don't remember what a precedent is, it's that once a decision has been made on a particular subject or crime, any future crimes that are the same exact will have the same punishment. It's an idea of keeping things fair and equal. It's also a way to say, you set the precedent. This is what it's going to be. If I decided every week I'm going to give you 5 points just for sending me an email, I've set that precedent. Every week, you know that you should send an email and you'll get 5 points. Even if I don't say it, I've set the precedent and now I have to abide by it. I'm not setting that up. Please do not take that as me saying, yes, this is what it is. It's just an example. So, as I said, we've talked about this before because the Constitution uses precedents. This is the whole reason why we keep going back to the Constitution, to make sure a law is constitutional, to make sure things are fair and equal, is because a precedent has been set that says that when you commit this crime, this is what your acceptable punishment is. And so our text brings up Marbury versus Madison from 1803. This is where the decision that the Supreme Court has power to strike down any law or government action that violates constitutional principles. That's when that precedent was set. That's when we realized that, okay, right here, this is what the not amendment. Geez, Constitution says. So yeah, this is what we're going to go by. And so, as I kind of said before, most of our modern statutes, most of our modern laws really are established from observation and experience. Not really common law, but common law still is a decent factor in this. Usually, the state or federal government who makes the decisions on whether a law is constitutional or not, they're the ones that really rely on common law more. So it's just important to understand that common law set the basis. This is where it comes from. Historically, it's very important. It's still used today, but a lot of our modern laws aren't necessarily directly related to common law practices, but it does still have a place. All right. And so when we think about state and federal decisions, one of the things that our textbook talks about is government agencies and commissions are these weird things that are both judicial and legislative in nature. So, they're able to enforce rules and set rules at the same time, but they're also not judicial systems, but they are. So they have a jurisdiction, but they don't have a jurisdiction, but they're set by like the president, and it's a confusing thing. And when you were reading through it, or if you're just listening to this now, it can be a little bit confusing, but I want to try to clear that up if possible. The textbook brings up a couple examples, and it is important to at least talk about those examples. So I'm going to write them down right here real quick in the blue, and then we'll talk about what exactly they are. Why did it make that super skinny? All right. So these are three different government agencies, or in the first one's case, a commission. We'll talk about that just in a second. These are kind of like sub-branches of the government. If I was to use a really bad example, they're part of the overall government. The judicial system, they still have to abide by the laws set by the Supreme Court and Congress and all that. Like, they still have to abide by those, but they can make specific rules that have to be followed that the courts don't have to agree on. And so that's where these agencies come in. That's why I say they're kind of this weird hybrid in between. So the FTC is the Federal Trade Commission. The IRS is the one that most people know of. That's the Internal Revenue Services, or revenue, not review. Wow, I am terrible with this today. Internal Revenue Services, and then the classic EPA, Environmental Protection Agency. They're all government agencies. They're all part of the, judicial system, but they're also part of the legislative. So they make laws, they enforce laws. The IRS, they're the ones that make sure you're paying your taxes and you're not cheating. Plain and simple. The Federal Trade Commission makes sure that, businesses and whatnot are following proper procedures, things like that. Making sure no illegal practices. And then EPA, the Environmental Protection Agency, they are an interesting group only because they work with, the environment. Their whole point is to make sure that there is not a harmful impact to the environment around the United States, but at the same time, they also get their funding. So when their funding is cut, they can't do quite as much, and sometimes they don't do enough. It's a whole thing. If you're interested in the Environmental Protection Agency, feel free to look into them. They try to do a lot of good things, but at the same time, there's a lot with them. But they are a government agency. They are a legislative branch piece, but they're allowed to enforce any kind of rule that they put in place about the environment. So when one of these groups or one of the other commissions or agencies that are the government stuff, like Like I said, they're like a weird offshoot branch. When they make a rule, it's not just called like a regular law or anything. It's called an administrative law. They're a very specific subset. It's the idea that it's not from Congress or the Supreme Court. It's from these agencies to make sure that these things are followed. All right. So coming back to this first term that we use, substantive criminal law, we broke down the different areas and types of law that are there, and we talked a little bit about common law and precedent. But so now the whole point of substantive criminal law is that there is no crime without law. And let me say that one more time and just follow me with this. There is no crime without a law. And so this is the idea that laws govern people, not a person. This is where the precedent from the Constitution that no man is above the law. Laws are rules that everyone follows. Laws govern people, but not an individual person. It's the you can't see the forest through the trees kind of concept. It's the whole group, not just an individual. And so that's what we're really talking about here. And so remember, and this is something that I put in, it wasn't necessarily in the textbook, but it's important. The U.S. government does not have unlimited power over its people. Yes, they set laws and rules that we should follow, and we should follow them. But they do not have unlimited power. And so this is where our chapter actually does dig a little bit into this. There are limits to what our legal system can do because we are a democratic republic. We do have certain rules and things in place. It's these things that make us unique when we talk about the criminal justice system and the legal system compared to the rest of the world. It's these things that allow us to be critical of our government and be able to, have that freedom of speech to talk about things without being arrested or killed on the spot. Now, there's some conspiracy theory stuff that could dive into this, but we're not going to. I want to at least talk about these are things that Congress and state legislatures cannot pass laws regarding. And so our text brings them up, and these are things that are common in other legal systems throughout the world. So the first thing is they cannot enact a bill of attainder. And bills of attainder are where a person or group is declared guilty and subject to the punishment without a trial. And if you're thinking that, well, how is that possible? Remember, the idea of a fair trial, innocent until proven guilty, which isn't actually said, but we like to believe that, that's from our Constitution. That's not a legal precedent in any other country. That's our country is that. That is, we cannot do this. Now, some other countries may follow suit. I'll be honest, I haven't looked too much into other countries and whether they have bills of attainder or not. But the idea is, here in America, you cannot be declared guilty and have a punishment without any trial. You have to at least be informed of what it is, and at the very least, when we talked about the judicial system last week, you have to at least have your crimes read to you and you get to plea. That's the bare minimum. This is saying that you don't even get that minimum. You don't get anything. You just get declared guilty on the spot and you get your punishment. So that's one thing that our government cannot enact according to our own, our rules that we've set up. One of the other things is we can't do ex post facto laws. This is just another one of those Latin ones. And this is just the idea that an act committed before it was made a crime is now punishable. So this is like retroactively arresting someone. So let's say, and this is both a good and a bad example, because as marijuana has become decriminalized in Erie, and as it's becoming more and more decriminalized throughout the United States and becoming more commonplace. This would be if the opposite happened, if it was not illegal and then all of a sudden they made it illegal. If you were known to have marijuana 10 years ago, you haven't touched it in 10 years, but you used to, and now it's illegal, and the police decided, oh, well, we know that you did it 10 years ago, so we're going to charge you for that crime from 10 years ago. That's not how that works. That was before it was an official crime. So this is one of those, if it didn't exist as a law before, you cannot be punished for it because it wasn't a law. This comes into a concept that we have talked about before, and something we're going to talk about today, but it's the idea that you're not aware that it was illegal. So we'll get to that. And then the last one, and this has to do with the fair and speedy trial, but this is more than just that. Our system, we require that you must provide fair notice. And fair notice doesn't just mean enough time. It also means that you're avoiding any vagueness in what the crime is. So this idea is that the law is clear, and it's clear enough that people, a reasonable individual, a normal person, can determine exactly what is and isn't allowed. So it's the idea of, we all know you shouldn't kill. Boom. There's no vagueness to it. But if we had a law that was kind of wishy-washy that said, you really shouldn't walk around without a shirt on Saturdays, but Sundays it's okay, and Fridays it's okay, but just Saturday is not okay, does that mean from 12 a.m. on Friday night into Saturday and then till 11:59 p.m. on Saturday to Sunday? Or is that during the daylight hours? Or it's too vague. And obviously this was a very ridiculous example. It's not at all serious anywhere. But this is what we mean by it's reasonable. It is fair notice. It's not just, oh, well, you broke the law. What law did I break? Oh, this one that says this. Is that what that means? It gets into a bigger issue when you have very wordy things, which is why we try to have our modern laws be very straightforward. Anyway, just wanted to say that, those are really the three that are textbook highlights. That's important to note that, we're not supreme law. We do still give you rights to do things. All right. So then our text talks a little bit, and this is where I get into here. So fair notice and vagueness, this is exactly what I was just saying. This is the due process clause of the 5th and 14th Amendment. Anyway, so our textbook then talks a little bit about the amendments themselves. And so I did just want to talk a little bit about these because these are things that tend to get misinterpreted or misused a lot, but they're also important to understand what exactly is being meant by them. So this is a good start. Obviously, one thing that is really hard to explain is these documents, the original Constitution, Bill of Rights, all this is hundreds of years old. It is not something that we know exactly what people think, what people mean. We don't. It's been too long. We do not have that information. But we can get a pretty good idea. And so this is the best way of simultaneously following the word of the law as well as explaining what it means. And so the First Amendment, this one is the one that people love to pull. This is the freedom of expression without punishment. We always say the freedom of speech because that's really where the expression part comes from. Freedom of speech. It's important to note the freedom of speech, it's not that you can say whatever you want. It's you have the freedom to speak however you want without retribution or punishment from the government. That's the piece. Without fear of punishment. Technically speaking, yeah, you should have that freedom to say whatever you want without being harmed by another individual. But there are some examples or exceptions to this rule, and that's what this talks about. And this is why it's important to actually identify these kind of sub-breaking rules that people tend not to think about. So our text even has a clear and present danger test. This, one of the main things when the government can supersede, or a criminal case can supersede a constitutional right, and that's any constitutional right, by the way, is when it is in direct violation of public health and safety. So this is where, and it's important to mention, Schneck versus the United States in 1919, this is, you cannot say inherently dangerous speech, such as shouting fire in a crowded theater when there's not a fire. That is illegal. That is causing a public panic, and that is potentially public safety that is being directly hurt when there is no danger. So that is a clear example of this. This is where inciting violence gets into this kind of area. It specifically gets into the other thing, which is our fighting words. Yes, that stupid phrasing that you've probably heard a million times before, them is fighting words. Yeah, this is where not really speech that's covered by the Constitution or your amendment right that you are allowed to say whatever you want. Not if it's meant to incite some kind of violence. And that's the piece. Any speech that's calculated to incite a violent reaction. If you are saying it intentionally to get someone to violently attack, it is not protected under free speech. This covers hate speech, profanity, libelous utterance, which we'll talk about here in a second, and obscenity. So obviously profanity and obscenities, I think we can understand. Swear words, sexual discussion, things like that. Those are not okay. They tend to make people uncomfortable. Hate speech should be pretty obvious. Don't be racist, don't be sexist, don't be any specific religionist. Don't be hate speech. Libelous utterance, you might be familiar with the term libel. That first part of libelous. Libel is where a false statement is made with the intention of damaging a person's reputation. And this is why I said it's kind of come back up as an example, and so we can talk about it. Libel is what the Johnny Depp Amber Heard case that was publicized was about. It's important to note, we talked about it in week 1, and I'm bringing it back up here, that the Johnny Depp Amber Heard court case that was publicized and everyone was talking about for months was not about abuse. That court case was a civil suit. We're using our new terms. It was a civil suit that was all focused around libel. The idea that Amber Heard's 2018 or 2019, whatever year it was, article that essentially called out Johnny Depp without saying his name had directly impacted his ability to get work. It affected his personal his personal reputation, and it affected his ability to do his job, to do his craft. That's what the case was about. Which is why when you look at all the evidence that was presented in the case, it was clearly in Johnny Depp's favor. Again, not saying that neither one of them are abusive or either one of them is completely innocent. Neither of them are. But for what the case was, it was a libel case, it was a First Amendment case, it was nothing else. It turned into everything else because we want to talk about all those other issues. But that case itself was all about defamation, all about libel. The idea that this one piece of article written directly impacted my ability to work. That's all it was. So when I mention that court case, and it's going to keep coming up because it's a recent example and a good example of what a court case is about and isn't about, I will always be talking about it from that stance. I'm not Team Johnny or Team Amber. I'm just telling you factually what the case is about and why it went into that favor. Again, both parties are guilty of abuse. I'm not going to sugarcoat that, but there's more to it. All right. Sorry, that was the fighting words part. I just wanted to get through that. It's important to note, we kind of whiz by it here, but the freedom of a religion actually follows the same kind of process as above. You know, you're allowed to express your religious beliefs as much as you want, realistically, as long as it doesn't, you know, hurt or negatively impact the health and or safety of the public, and it doesn't incite some kind of violence. So they do mention they've protected door-to-door solicitation and ritualistic animal sacrifices. That means, you know, they see them as those are parts of their practice, that they are not actively harming society or an individual. If you're an animal rights activist, obviously you can argue the ritualistic animal part, but for the most part, those are where it is. But some of the other freedom of religion things have not quite been held up, like snake handling, polygamy, and the use of hallucinogenic drugs. This is that area. If you never heard of snake handling as part of a religion, it's interesting. It's weird, and there is a group of snake handlers in the Appalachian Mountains here in Pennsylvania. Just a fun fact for you. If you want to know more about snake handling, I actually do. I have an article somewhere that I'd be glad to share with you about the history and practice of snake handling. It has nothing to do with criminal justice, but if you read that and you were like, what the heck? Reach out. Anyway, so just wanted to identify that freedom of religion, as long as you're not causing danger to any individual or society at large, and you're not trying to incite some kind of violent response, you pretty much are allowed to. Obviously, it's not absolute, and that's the other thing. Like, you're allowed to assemble publicly, but obviously if you're in a place where it's restricting something or whatnot, you tend to... the idea always comes down to reasonable. They also mention compelling state interest. This is the nice way of saying if the state has something planned and you are trying to hold your religious expression in a certain place and time that the state has interest in and is planned to do that, they can technically supersede it. It's a weird thing. It usually only comes down when it's jeopardizing public health and safety, but it is possible. All right. Second Amendment, and even I tend to get caught up in this one. The Constitution guarantees the right to keep and bear arms. Yes, it's plural. However, it is not absolute like any of these. It is by no means absolute, and there is so much debate about the Second Amendment constantly, partly because it was written, again, hundreds of years ago. It didn't count for what is our modern weapon. Like, let's be honest. The weapons that our founding fathers were talking about were flintlock and the good old-fashioned metal ball, shove it in, the gunpowder, the whole thing with the musket. Like, that was the arms that they're talking about. They're not thinking about automatic weapons that shoot hundreds of rounds a minute. They're not thinking of higher velocity weapons and highly precise weapons. That wasn't what they were thinking about. They were thinking about the weapons of their time. So that's why when people get into arguments about it, it's always, well, yeah, they said you're allowed to, but they didn't qualify. There's a whole lot of issues with it. So it's important to note, and our book is stating it here too, but the Supreme Court, modern Supreme Court, they established that the Second Amendment does give you the right to carry a firearm for self-defense. That's the important piece that people get caught up in. Self-defense. If you're a gun collector and you are getting frustrated, well, I'm sorry, the Second Amendment is your right to own these firearms and carry them for self-defense. You can keep them, but if you're just collecting them, that's fine. But to actually carry the firearm, like actively use it, it should be for self-defense or in hunting and other things. But that's a whole different thing. It's applicable to the 14th Amendment. Typically, restrictions include, and this is the other thing, the 14th Amendment says that it's to the states. So all the other things with this is state-run. So each state has their own restrictions, background checks, waiting periods, whether or not you can conceal carry, even if you have a concealed carry permit for one location but not for another, purchasing, limit of firearms, limit of ammunition. All those things are determined at the state level. It's not a federal thing. And so when people get all frustrated and say they're taking away our Second Amendment rights, it's not that. It's really, the argument is that when we talk about gun regulation in the higher levels of the criminal justice law field, it's always taking some of those state specific restrictions and saying, do these need to be at the federal level or not? So that's an important distinction. Like I said, this is a very hotly debated topic. I don't want to dive too much into it, just because it drives me crazy. Okay, Eighth Amendment. The Eighth Amendment, this is where we get the concept of cruel and unusual punishment. If you remember, we said, and I couldn't think of the term earlier, but proportionality. The idea for cruel and unusual, or rather, you can impose cruel and unusual punishment on an individual in our judicial system, is that you can't, cruel and unusual doesn't mean cruel and unusual. What it means is you cannot punish someone disproportionately for their crime. If you stole a candy bar, you cannot be put to death. If you got in a fight with someone and so you beat the crap out of them, you can't be tied to a stake and whipped. Like, that's cruel and unusual punishment. It's the concept that proportionality is met. That's what the Eighth Amendment's idea, that you can't have cruel and unusual punishment. Cruel can mean one thing to me and mean something different to you. Unusual can mean one thing to me and another thing to you. Without diving too much into it, if you really want to be weird, there is the idea, the subculture of BDSM, that is, some people are into pain. So if you're punishing someone for an act that is into that and they enjoy the pain, is that unusual? Depends on who you ask. So again, the concept of cruel and unusual punishment is not like the everyday words that we use, cruel and unusual. We really mean that it is an disproportionate, oh my gosh, why? Punishment. Disproportionate punishment for a crime. And so this is where, the textbook does bring it up, at least. The legal controversies of three-strike laws and the death penalty, they'll be talked about later in this text, but this is where they fit in. This is where the Eighth Amendment, cruel and unusual punishment, three-strike laws, like that is a very specific thing. If you're not familiar with three-strike laws, it's the idea that, you once you break the law, particular piece 3 times, that's when you get a harsher punishment. And then obviously the death penalty, this one is a difficult one. And hint, hint, this is going to be part of the term paper, is the death penalty is going to be an option. So I just want to put that out there. Is the imposition of the death penalty constitutional? Just going to put that out there. That's going to be part of the essay. But food for thought. All right. And then because we have to talk about it, the right to privacy. And before we even look at that, I don't want to go anywhere else. I want to ask you to think about it. Is the right to privacy one of the amendments? I'm giving you just a second to think about it. What amendment is the right to privacy? And so technically, it's not in the Constitution, not expressly mentioned. There's no mentioning of a right to privacy in the Constitution or the amendments. We agree that the right to privacy is a human right. And you know what? The Supreme Court agrees. A lot of individuals would say, yeah, your right to privacy is important. This is, while not in the Constitution explicitly, it can be seen in some other places. So, like, they do mention, the right to privacy has been used to protect many controversial practices that were at the time socially unacceptable. It's important to note that, yeah, right to privacy tends to show up a lot in the controversial court cases. So like Roe v. Wade, which was the privacy rights argument, you have the right to get an abortion and not be punished for doing so because it happened in your private time. Lawrence versus Texas, where, and this is just hilarious, but not in a happy way, but in Texas there was a law that prevented any individual from having homosexual sex in the privacy of their own home. That was a law. If you were caught having sex in your private home, your private property, you were having homosexual sex, you would be charged as in breaking the law. Obviously, that case proved that, it's unconstitutional. What you do in the privacy of your own home means nothing. And so this is where this right to privacy is important to note. It's not in there, but it's in there. So the right of free association, prohibition against quartering soldiers in private homes, prohibition against unreasonable searches and seizures, all these things, these are things that are guaranteed rights through this, but right to privacy is part of this. And so that's why it's like, it's not explicitly stated, but it's important to note that the right to privacy is there. It's just not black and white. And so just wanted to put that out there because the text does bring it up and it is an important piece. And I really think that more people should know that, the right to privacy is not explicit. At least not as explicit as we'd like it to be. But at least we all agree that we're allowed some semblance of privacy. All right, moving on. And we're going back to the text. And we're going to talk about the elements of crime. The argon, iron, bronze, steel. Steel's not an element. Crap. Sorry, I was trying to make a bad joke and I just made it worse. When I talk about the elements of crime, what I'm talking about is the qualities that certain crimes share so that the government can point to it and say, yes, that's a crime. All crimes tend to have something in common with another crime. And so something that is brought up here is another, couple wonderful Latin words, but the text does a really good job of giving us an example right off the bat. And that is, where is it? It's manslaughter versus murder. Where is it? Oh, it's in this section before this. Whoops, can't do that one. Okay, but they do bring up, what's the difference between manslaughter and murder? And I'd ask you, what's the difference between manslaughter and murder? And what it comes down to is one's kind of an accident and the other one was intended. So murder is you have the intention that you are planning to kill this individual. Now, of course, there's a difference between involuntary manslaughter and manslaughter, but the idea is that with manslaughter, you didn't start off and intend to kill someone right at the beginning. You intended something else. Maybe it's you intended to drive your car real quickly down the road and just see how much public damage you can cause. And you hit someone. You were recklessly driving and you hit someone and you killed them. That's manslaughter. Technically speaking, it's not quite involuntary because you knew you had a likelihood of doing it. You knew you had a likelihood of hitting someone and killing them, but you did it anyway. And we're going to talk about that in a second too. But it was an accident. You didn't mean to hit and kill the person. It just kind of happened. Murder, you were like, oh, I am going to kill Mr. Wheaton today. I am going to make sure that I leave my house, I get in my car, and I'm going to drive straight to him and just boom. Like, that's murder. You had planned it. And so, like I said, there's a lot of Latin words that are going to come up here. And so I just kind of want to put down the one that was mentioned regarding murder. And that's malice aforethought. And if you know anything about Latin, or you know English really well, or you play Legend of Zelda Breath of the Wild, and you're familiar with the term malice and other things and whatnot, gosh, why is it zooming in like that? I don't like that. Okay, malice aforethought literally is just, it comes down to the idea of premeditation, and I'm sure if you've watched any kind of crime show, you've heard of premeditation before. Malice is usually translated to evil, and aforethought is before you act. You've thought this through, you've planned it out. So evil intent is where it really kind of translates to, but this is the idea that you premeditated that you were going to kill this person. This is something that is part of an element of crime, is that there was the intention to do it. And so we will kind of put that here, and that's intent. And that's the modern English word that we use to talk about this, but intent is a element of crime. Was it intentional that they did this way, or did this particular crime, or was it an accident? Actus reus is one of the other ones, and this is just a guilty act. And it's important to note that when our text talks about act, and when this definition uses the word act, it's almost a misnomer because it implies, if you know your English, act is a verb. You are doing something. You are actively doing something. A guilty act can be actually doing something, or, and the text mentions this too, it could be an omission of acting. An omission, you're not doing it. So if the law says you have to do something and you don't do it, you are committing a guilty act by not doing what you're supposed to. This is like if you're a parent and you're raising a child and you decide not to feed them, not to give them clothes, not to give them water, to kick them out of their house before they're 18. Like, all these things that you're not supposed to do, you are omitting. Your omission is that you're not caring for the child, and so it is a guilty act. Anyway, it's just important to note, like, that's what we're talking about when we say act. And the other thing to note with actus reus is that it's voluntary act of some kind of illegal crime. Because there is something different when it is, coerced. And we're going to talk about that here in a little bit too. So really, there are a couple things, and mens rea, rea, R-E-A, mens rea really is part of this malice aforethought. It's like the combination too piece. How I want to distinguish between the two. Give me 1 second. So mens rea doesn't necessarily mean that you had bad intentions. You just intended to commit a crime. This is the bad example that I used, I believe, last week of you break into a house intending to get out of the cold, but you steal something. Your intention, your mens rea was to get out of the cold. That was the intent. If you purposely broke in planning to steal something, you had more of a malice aforethought to steal. Anyway, that's less important. I'm getting it more muddled up than it needs to be. Just know are two things that all crimes have to have. These are the two big ones. These are the hefty ones. Actus rea and mens actus reus and mens rea. You need a guilty act and you need intent. The intent part, oh my gosh, it just does not want to work for me. Okay, now it is. This really comes down to you have a physical aspect and a mental aspect. The intent is the mental. The actual act itself is the physical part. And so in the modern penal code, they break this idea, this mens rea, the intent, into 4 different states. And I always try to think of a weird, stupid not anagram, like some kind of word. Anyone that's taken me for English 101 or 102 knows what I'm talking about. We have kelp and tapic. I hate that I'm using this one. This is the only one I can think of. You want to make sure that you are talking about your peckern. Yeah, not the greatest. I could have picked anything better, but you'll understand why I chose those letters here in a second. Knowingly, recklessly, and negligently. So, again, if you've had me before, you know I try to think of clever ways to remember things. PKRN, I couldn't think of a better way of saying it other than Peckern or Peckern, and no matter how you break it down, it's awkward. But it's a good way of remembering. The way our modern system works, the modern penal code breaks down this idea of intent into 4 areas. There's purposely intent, so you are purposely planning on it. It's purpose intent. You consciously have a desire to commit that crime. So you woke up and you chose murder. You woke up and you chose arson. You woke up and you chose kidnapping. You purposely planned it. Knowing intent is you know roughly what the result will be from your plan, but maybe it wasn't your express purpose. This is where we kind of get into that, breaking into a house to escape the cold kind of thing. You know that it's going to be bad no matter what, but your express purpose wasn't, oh, I woke up, I'm going to steal from these people. No, it was, I knew I wanted to break into a house today, but you know what? I was there and I saw something I just had to pick up. You knowingly knew it. Reckless intent is where we get into our malice aforethought example of, choosing to drive recklessly down this road. Yeah, I chose the word carefully. Reckless is where you disregard the risk that your crime would do that a standard citizen would observe and go, yeah, I'm not going to do that. Recklessly means you take common knowledge and go, yeah, no, I'm not doing that. I'm going to do whatever I want. You're disregarding all risk involved. Negligently intent is all about you should be aware of the risk. A careful person would, but you weren't. So negligent isn't always necessarily that it was your fault, but it wasn't your fault. Reckless means you know it's wrong and you just did it anyway. You just didn't care. You didn't care about anything involved. Negligent tends to be, you should be aware that you can do it, you shouldn't do it, and why it's not, but you weren't sure. So it's a gray area. We've talked about gray areas in last week's thing, so it's just important to keep knowledgeable and up to date on that. All right, that's the 4 breakdown of it. Obviously, I don't know that my description is the best. Obviously, go to the textbook. If you want to look up more, please, by all means, use Google. Google is fantastic. It has a lot of information available to you. I'm trying to make this as accessible as possible. Sometimes by making it more accessible, I get lost in the words. So if you're ever confused by a lecture, please email me and be like, Mr. Wheaton, what are you talking about here? I'll be glad to talk about it and try to fix whatever confusion I caused. All right. That covers that piece that I want to talk about, those key elements of crime. And so there is something that's related to this in crime that the textbook puts in that chapter as well, but it's... I'm just going to write it. Strict liability. Strict liability offenses are part of crime, but this is the idea that they're a crime that doesn't have a culpable mental state. So, whoops, I want to do that. And then go... This is really what this post-it note, what strict liability offenses are. It's the crime itself doesn't require intent. These are things that in a court case you wouldn't need to prove the intent was there. These are things like speeding. No police officer, judge, or jury in their right mind needs to prove without a doubt that you intended to speed that day. No. You don't need the intent to do it. You just did it. It was a guilty act. Plain and simple. Another one that they bring up is statutory rape. And if you don't know what that is, it's very different from the larger word that's part of that. They vary from state to state. It's the idea that, if you're under the age of 18 or whatever the age of consent is in your particular area, you cannot have sex with someone who's above that age. That is what statutory rape is. Plain and simple. That's why it's at different levels, and it's one of those, you don't need to prove that they intended to do it. It's like you did it. Plain and simple. I don't need to prove that you mentally planned to do it. No, I don't need to prove that you knowingly engaged in it. It's just, you did it. Period. End of story. All right. And so, in the criminal justice system, when we have these two things, this actus reus and mens rea, this is what we call concurrence. And I probably should just write that word here real quick. So make sure I have it. E-N-C-E. I believe that's spelled correctly. Let me check. C-O-N-C-U-R-R-E-N-C-E. Yep. Concurrence. So when actus reus and mens rea are both there, this is concurrence. This is when both intention and action are brought together, and we can see that. So this is the person intends to break into your house to steal your TV. The intent was there. The act was there. Person breaks into your house to avoid the cold. That was their intent. But they stole the TV. That's just the guilty act. There wasn't the intent to do that. It's a whole thing. It's an example that's going to be coming up constantly. All right. So it's just important to note that concurrence is when we have both of these. If we don't have both of them, we don't have concurrence in the criminal justice system. Boom. Done. All right. So let's talk about section 3.4, legal defenses. Partly because this is one of those Hollywood has directly impacted this system and people have a misunderstanding of it. So it's important that we talk about this area. So legal defenses is just, it's broken down into justifications and excuses. Obviously, justifications are easier to understand only because we tend to think about these. So justification is when we know that the crime is illegal. We know that we're not supposed to do it. But in this particular situation, it is understandable. This is, self-defense. The text even brings it up. It's a crime to shoot someone dead on the street, but if that person was a mugger and had you at knife point, then killing them in self-defense actually is a pretty good justification. Justification can also be things like, you stole food. You stole a lot of food from a supermarket. You did it because, you were trying to feed your starving family. You can see that there is some justification behind why you broke the law. You knew it was wrong, but you had to do it out of necessity, or there was a reason for it. Justification is the easier of the two. That's the one that we can think of and we can go, oh yeah, that makes sense. Excuses and exceptions, that's where things are different, the excuses. And so we're going to talk about this. The excuses that the text goes over, this is the big Hollywood one that everyone loves. The insanity defense, that, you claim to be insane and then, you get off scot-free. That's not at all how this breaks down. Again, this is the Hollywood really plays it up, but legitimately the insanity defense is very difficult to prove to a court and very rarely is used because of this. Really being 100% honest about the insanity defense and the insanity plea, it's very strict that you could not, based off of your mental state, there was no way that you could have known what you were doing was right or wrong. And because of that, instead of being locked in a prison cell, you need to be put into an institution oftentimes longer than what a sentence would be in jail just to get the help. So, it's not a get out of jail free card. It's very opposite of that. And that's why it's Hollywood really plays that up, but that's not what it is. So really, it's the perpetrators lacked the capacity to understand what they were doing was wrong or to understand the nature of the act. That's the official kind of definition. Boom, right here. The act was wrong or did not have the capacity to understand the nature. This, our text brings up, and this is kind of why it's such a hard thing to prove and why it's not used. So it's gone through a couple different phases, but they talk about, McNaughton rule, and this was a test that really was to see if you could distinguish right from wrong. And then it went to the irresistible impulse test, the idea that under your current mental illness, you cannot control your actions, despite the fact that you know it's wrong, and that's the piece. It was you can't control your impulses. The modern test, the substantial capacity test, kind of combines the two of them. So it's the idea that, according to the test, you are not culpable for a criminal act if, when you committed the crime, you were under a mental disease or defect that you were unable and you lacked the capacity to appreciate the wrongfulness of your conduct, or you could not conform the conduct to the requirements of the law. In big fancy words, or rather in everyday speech, at the time of the crime, when you did it, your mental state was so negatively impacted that you could not understand what you were doing, or you could not do what you were doing within the confines of the law. It's very particular, and it's not, like I said, Hollywood likes to play it up, but it's not how it goes. It's a really hard thing. Very few people ever actually get the insanity, innocent by, or not guilty by reason of insanity. They do have that, but it's not often. All right. I did want to just talk about that because it's a whole issue. Entrapment is another big one that comes up simply. How do I want to say it? If you're familiar with like crime shows or anything that has prostitution in it, you've probably heard the term entrapment before. This is the idea that law enforcement persuaded a person to commit the act without intent. It's important to note, and they even say it here, mere solicitation to commit a crime is not inducement. So just because a prostitute wearing a wire or a cop undercover solicits you to participate with them, that's not them actually inducing you or entrapping you to do it. You were planning to do it. The idea is that you have to show persuasion or coercion. So just because they're saying, hey, want to do it? That's not persuasion or coercion. They're just saying, hey, you want to do it? Like that. That's why entrapment, like I said, it comes up a lot in the line of sex work and the legal nature of that. The whole concept behind this is that law enforcement is persuading you to commit a crime. You know it's wrong, but they are convincing you to commit the crime to purposely get you in trouble. If you reach out to a prostitute on Craigslist to meet up and you meet up with a police officer, I'm sorry to tell you, but that's not entrapment. You were soliciting, and that is a crime. Now, and I'm not sure how many students in this class are on that board or not, but there is a debate to be made about sex work being legal, and that would do away with solicitation and entrapment issues as far as that's concerned. But that's not the place for this. I only know that because some of you I had for English class and some of your papers have told me more about what you're interested in talking. So I do want to at least bring that up. All right. Self-defense, as I said, we've already talked about it pretty briefly, but we've kind of really, this is the key point and the takeaway of self-defense and what everyone should take away from it. The legality of using force in self-defense hinges on the reasonableness. This is, was the danger imminent? Was it deadly? If it was deadly force that was trying to harm you and you would die if you had not shot the person, then you have every right in self-defense to do it. If they were coming at you with a newspaper and you shot them, I'm sorry, that's deadly force. That is unreasonable. So it's a whole thing. But ultimately, at the end of the day, typically self-defense is fine as long as it's reasonable. Remember that proportionality for laws, it applies to the citizens too. You can self-defend yourself. Just don't try to attack the person with something 10 times worse than what they were attacking you with. It'd be like if someone came up to you with like a tiny, like my first Swiss Army knife from Boy Scouts, and you just pulled out a shotgun. Like that one is way more dangerous than the other. Obviously I'm making light of that, but that's what we mean. It's reasonable self-defense. Intoxication, how do we talk about voluntary intoxication and involuntary? I'll talk about that here in just a second, but intoxication, really, some people try to use the logic that because I was intoxicated, I was unable to make a conscious decision and therefore I shouldn't be punished for the crime. Obviously, voluntary intoxication, you chose to do drugs, you chose to drink, whatever it may be. A lot of times, it pretty much just kind of hurts your case more than anything. Obviously, and they mentioned like in murder, if it's first degree murder, they might reduce to second degree if you were under the influence. Because, yeah, maybe you were going to kill them, but you ended up being worse. Or maybe you just meant to harm them, punch them, whatever. You were just going to assault, but you ended up killing them. Like, that's where it gets into that different levels. But involuntary intoxication is a completely different matter. This is, you've been drugged. You were given Rufalin. You were had a spiked drink and you didn't know it was spiked. You were intoxicated against your wishes. You did not know. And if you committed a crime at that time, then yeah, you could make a defense that you were involuntarily intoxicated and you couldn't make that decision logically. That's possible. But you also have to prove without a shadow of a doubt that you involuntarily engaged in it. Because it is important to note, everyone recognizes that everybody makes mistakes. It is possible that a mistake could be made. A mistake of fact, like, you showed up to a situation that was really, not what you expected, and one thing led to another, and maybe you got in a fist fight and you got in an assault. You made a mistake of fact. You thought it was going to be a get together and it ended up being a violent party. Like, yeah, there is a argument to be made there. But mistakes of laws aren't usually taken, and that's simply because the idea is that most people should know. It's the presumption that you should know criminal law. You know what you shouldn't do. Don't kill, don't steal, things like that. Yeah. That's mistake. Like I said, this is the classic, slap on the wrist. You made a mistake, but it wasn't deadly. It wasn't the end of the world, so we'll kind of let it go. Necessity, this is an interesting piece. They use the example, this is also referred to as the lesser of two evils defense. This is the idea that the crime you chose to commit was committed for the purpose of avoiding a worse crime. And so the best example to give is right here in the text, and that's where property is destroyed to save lives. For poops and giggles, let's say that you are driving a vehicle that the brakes aren't working. And it's a red light coming up and there's a group of children walking across the street. You can't stop. So right off of the road is a small house. And you have to decide, do you hit the children and kill them on impact because you're going fast and you can't stop? Or do you turn into the driveway and into the house and potentially, break through the front living room and do thousands and thousands of dollars worth of damage? It was a necessity. The lesser of two evils was to damage that property rather than kill a bunch of school children crossing the street. Necessity is a hard one to talk about, only because you recognize it as it's the classic damned if you do, damned if you don't. Which one is going to be the least problematic? So sometimes it is a defense. And like I said, it's almost always in some kind of life or death kind of situation where a group of individuals tend to be, that's the most evil, and the lesser evil is, burning a building, getting in a fight, causing a public disruption. Like, pick whatever it is. It tends to be that. Tends to be. Not that it can't be others, but it's important to mention that. Remember when I said coercion? This is it. Duress is more commonly known among the, not criminal justice field as coercion. This is the idea that you were forced to do the criminal act. the idea is that you don't have that criminal intent, the mens rea. You were not intending to commit any crime. The problem is you were threatened through some kind of force or the threat of force. Yes, you were either forced or you were threatened by force to commit a crime. Whether that's harm to yourself, to your family, whatever it is. But another individual is forcing you to do it. This is where the famous Erie case, the pizza bomber, comes in. Was the individual coerced to wear the bomb necklace piece, and like they were coerced so they could make the argument if they had survived. It's a whole thing, but the idea is that, Hollywood likes to do this one too, where the mafia tells you got to do this if you want this person to live. Like, that's coercion, 100%. There's no gray area on that one. That's coercion. All right. And so from chapter 3.4 to chapter 3.5, we're really just wrapping up these two chapters because they break down to legal defenses and substantive offenses. Substantive offenses are the big ones. These are the ones that, we talked about. Common law, these are the ones that, much of them haven't changed. These are the big ones. These are the, you're not supposed to do them. Like murder. And this is where, ill will or aforethought, malice aforethought comes back in. Like I said, ill will, evil intent, that kind of thing. Murder is killing another human being with malice aforethought, with ill will, with preemptive decision to do something. What's important here is that, technically speaking, if the intent was to only cause grievous bodily harm, technically, so murder with intent to kill, that's the malice aforethought, is one legal way to look at it, but common law also says it could be satisfied simply by, you planned on beating the living pulp out of someone. You planned to beat them within an inch of their life. And then you did actually kill them. Yeah, you had the malice aforethought. You had the ill will. You committed murder. It wasn't manslaughter because you planned on doing enough damage that reasonably it would have negatively impacted their life. So that's kind of important to note and why I wanted to at least talk about it. As long as there was that intent to cause severe bodily harm, that is enough of quote unquote forethought that it could be seen as intent and could be, put as murder. They talk about depraved heart murder where, you don't really have a target. There's a lot of different sub breakdowns, and I don't want to dive too much into that one because I think we understand murder well enough to know that no matter how it breaks down, if you killed someone, unless it's some kind of way out there reason that it just couldn't be avoided, it tends to be illegal at all levels, and the forethought almost doesn't really matter. Sorry. It's hard to really talk about it, partly because it's just a hard one for me to talk about. Assault and battery, this is difficult. And the reason I say difficult is because typically they are used interchangeably. And so the text even says in many jurisdictions, they are two distinct offenses. Fun fact in PA, they are interconnected. They're not interchangeable, but assault and battery are not two distinct offenses. They are they're the same for PA. You'd be charged with assault and battery, not. And if you're charged with assault, it's assault connected with something else. Battery's connected with something else. They're not two distinct offenses. They're kind of always intertwined in some way, shape, or form. But the idea of assault and battery, just to clear up any confusion, is that some harm is going to be caused to the victim through some kind of physical act. That's really all I need to say about that. We did talk about rape earlier. Do note, because of the previous issue that, courts said that you had to prove that you were a chaste individual before this thing, which is totally not okay. There are rape shield laws in place now in most states, which means that your past history cannot determine whether or not it was legitimate, which is nice. We finally got there. And the other not fun but fun fact is that the Uniform Crime Report from the FBI, the changing climate around rape law has actually, influenced the main definition that they use, and which is what the main definition that most people refer to as. So when I mentioned earlier the changing definition, it's all because of how we go, well, it doesn't count this, it doesn't count that. You can make a change. You just have to be pushy. Arson, your intent is to burn something down, some kind of property, and that's important. It's always been a serious crime simply because, either you're burning down a house or you're burning down things. As we got further and further, we added things in your domicile, your home. When it's burned down, that's part of arson. Robbery is, taking property from another person by use or threat of use of force. Burglary is you break into the place and you steal something typically, or you commit some other crime. This is where they say, other things can come into it, but they also are qualified under burglary because you broke in to do it. And then I want to just wrap up, and this is really where I wanted to go. I didn't want to focus too much on explaining what these types of offenses are, simply because I think most of us understand what those are just from the outside. Like, you look in and you go, yeah, I know what arson is. Yeah, I know what burglary is. Yeah, I get what, robbery. Sometimes people get confused on robbery and burglary, which is why I did talk about those two at least. I know what assault is. I know what murder is. But the chapter does end with, again, our book does a good job of talking about the juvenile system. And again, obviously, a lot of the stuff that is talked about for the juvenile system of criminal justice will be talked about in our own criminal justice, our own juvenile justice class. So I'm not going to dive too deep into it, but I am going to talk about a couple things here. And that is that in the juvenile system, they are broken down into 3 type of offenders. So, as we have in the adult system, all these different, you commit this crime and this crime and this crime. The juvenile system breaks them down into 3 simple ones: delinquents, status offenders, and dependent and neglected children. Delinquents are the ones that, and you've probably heard the term delinquent before. This is any youth who commits an act that would be considered a criminal offense if they were an adult. So whether it's a misdemeanor or a felony, arson, murder, whatever, this person isn't called a felon. This is a person that's called a delinquent. When they become an adult, and if they're still part of this, then yes, they would be under felon and all those other fun distinctions. But in the juvenile court system, they are just a delinquent. A status offender, and this is where I have heard too many times people refer to this group of juvenile offenders, the status offenders, is where people tend to also call them delinquents. They're not. But status offenders are just youth that their crimes would not be considered criminal if they were an adult. The only reason it's a crime is because their age. These are things like truancy, which is, not going to school when you're supposed to be, running away from home, curfew violations. Like, if you are under the age of 18 and you were out of the house after, 11 p.m., 10 p.m., whatever it is, you're not a delinquent. You're a status offender. You're not really causing problems. So that's why it's like that one. People tend to use delinquent to talk about all child offenders, and it's not true. It's just important to note that. And then the last group is the dependent and neglected children. These are individuals who have been disadvantaged in some way. These are individuals who have really just need help. They need support, they need supervision, they need a parent, and they don't have that. These can be individuals who are running away from home. Can be individuals who are truant. These can be individuals who may have, committed some kind of minor crime, like, some kind of misdemeanor. I would be the better way to say that. But really, the reason they're acting out is because they're neglected. They don't have the basic needs they need. So rather than being a delinquent, they're more of the neglected child. So there are different breakdowns in the juvenile system. That's kind of the takeaway that I want you to get from this piece right here. Like I said, and I've said before, and I'll say it again, if you want to talk more specifically about the juvenile justice system, please take the juvenile justice class, which will be held in the second 8 weeks. This is an overview class of all criminal justice, so we can't spend a lot of time just talking about juvenile justice. So that's my piece. That actually also covers the notes for today, or for this week, I guess. Thank you very much for listening. If you didn't listen or barely listened, that's fine. I just kind of talked to myself and talked about criminal law. As always, if you have questions or concerns, let me know. Send me an email, awheaton2@ec3pa.org. This will go up, obviously, because Labor Day. All this stuff will be available. The notes, the weekly quiz, and things like that. That'll all be available as of the 6th of September. It will not be available Labor Day because it's meant to be a day off from school, so no work. So it will be available on Tuesday. But other than that, thank you very much, and I'll see you soon.